Good afternoon, everybody. Welcome back to another Q&A session. My name is Chris Justice, and I'm an employment lawyer with Samfiru, Tumarkin. I work out of the Toronto offices, and I am here today, as I have in the past, to hopefully answer as many questions as I can regarding all things relating to the employment sphere, the workplace. And in particular, I know that the hot topic is continuing to center around the COVID vaccine, the policies that companies are implementing with respect to this vaccination, and what, if any, impact it could be having on your particular work situation. So, as I customarily do, I'm just going to start with a couple general points that hopefully will address perhaps many questions that could be asked today. And that will have to do with the COVID vaccine policies. That will have to do with your eligibility for EI, should you refuse to get vaccinated or perhaps submit to testing, and that kind of thing. So, number one, I want to say right out of the gates that if you're an employee and you are being asked by your employer to comply with the employer's vaccination policy, there is a very good chance that if you do not comply with the policy, that you will still be owed severance and potentially other forms of compensation in that respect. So do not think that as an employee who's being put in a situation where you have to comply with the policy, that by refusing to do so means that you are not entitled to any severance, number one. Number two, I know that a lot of questions nowadays have been focusing on whether or not an employee is entitled to EI benefits in the event that they are to lose their job or perhaps be placed on a leave of absence or suspension of some sort. For refusing to get vaccinated or refusing to submit to testing, as an example. And what I will say is that if you're in a situation where the employer is claiming that you're not entitled to EI benefits, or you just aren't sure as to whether or not you're entitled to EI benefits, again, there's a very good chance that you will be entitled to those benefits. And so if your employer marks on your record of employment that you're not in some way, I would definitely suggest contacting us because there may have to be a need to have that record of employment revised to put yourself in a position to collect those EI benefits. I've got some questions coming in, so I'll start to answer some of those. And as noted, if you've got any questions about your rights, you can always contact us at employmentlawyer.ca. But having said that, I'll start with a question from Freedom on YouTube. Freedom is asking, if a contract employee is terminated due to the mandate, is there any recourse from the contract employee, even if they provided a religious exemption? And again, as I mentioned from the outset, if your employment has been terminated due to something regarding a mandate, a COVID-19 vaccination mandate, there's a good chance that you're still entitled to severance. So your recourse could be severance. One of the key things to note as well is that if you are an employee and you are being subjected to a COVID vaccine policy, the particular industry that you're in could affect whether or not you're entitled to severance. Now, again, for the most part, most industries do not have any form of legislation in place that actually requires the vaccination or testing as an alternative. And so that's the principal reason why you would be entitled to severance. But if you're one of the rare exceptions, I'll say, where there is legislation in place mandating either the vaccine or a vaccine or testing option, and you still refuse, then that could pose some issues, but definitely want to get in touch with us in any event to see what your rights are, because again, there's a good chance that you'll be entitled to severance and some significant compensation in all likelihood. So hopefully that answered your question, Freedom. I'm just going to go on to some other questions. Marion on Facebook says that she left her job on Friday. She refused to take the vaccine, and she works for a government-run development center. They had Marion mentioning that they had her sign a release with severance. Otherwise, she's on a leave without pay, and then asks, will I still have a case for human rights if I sign the release? So this is important. If your employer is asking you to sign any documents in exchange for severance, whether it has to do with a COVID vaccine policy or not, I would strongly urge you not to sign that release, not to sign those documents until you first speak with a lawyer. Not only could you be entitled to more in terms of severance, but again, there could be other amounts that you're entitled to, such as, Marion, you mentioned human rights damages. That could be a possibility as well. It'll all come down to the situation at the end of the day. So if you have signed a release, I would definitely suggest contacting us. You don't want to be held to signing that release. And if you felt at all pressured or under duress to sign the release, you may have grounds to back out of that, but that can become a huge sticking point. So you'll definitely want to get in touch with us if that's the situation, to see if we can be of further assistance. Tracy on Facebook asks, can I get a lawyer if I feel I've been misrepresented from union? So this has been a fairly common thing that I've seen for employees who are unionized. They feel as though their union is not advocating to the best of their ability on behalf of you as the union member. We as a firm do not specialize in unionized matters. So you'll have to get in touch with a lawyer, a labor lawyer in a unionized context. But what I will say, two things. Number one, to the extent there's any issue with the way in which your union is representing you, or with the way in which your employer is dealing with you, the starting points are often to look at the collective bargaining agreement, and as well consult with your local union rep and get an idea as to why they may not be representing to you to the extent that you want them to. It is very difficult to file for what's called a duty of fair representation claim against your union. So the odds aren't the best there. But I would start with the collective bargaining agreement and your union rep, and specifically ask the basis for why they're taking the position that they're taking. So hopefully that answers the question to your satisfaction. Thanks again, Marion, for that. Tracy, my apologies. I've got some other questions in here, so just bear with me. Belinda on YouTube is asking, can I claim a wrongful dismissal if my employer let me go for untrue reasons? And I would say the answer to that would be potentially. It will depend. Certainly, if your employer is saying that it's letting you go for specific reasons that as a fact are not true, and you can prove that, then there would definitely be an element of bad faith involved in that. I don't know how much of a dispute there'll be on whether or not these reasons are valid. But in general terms, employers need to provide a valid reason. They can't be lying and using one reason as a means to conceal their true motive. So the question will come down to what evidence do you have and can you prove it? And as well, to some extent, what the reasons are from the employer side of things. But if you feel as though that is the case, then definitely get in touch with us, because you may not only be entitled to more in terms of severance, but also additional damages to the extent that you can make out bad faith claims such as that one. So I've got another question coming in from Vicky on Facebook. Vicky is stating that her religious exemption has been denied, and that the exemption is not based on personal beliefs, but Bible passages, and that you sent them a letter from a religious leader, and you're asking what recourse can you have them to reassess your exemption. So when it comes to exemptions to the vaccine, I should say, normally there are a number of reasons why someone might be able to object, but it seems as though the most weightful reason has to do with the medical exemption. And I think the circumstances that would make out a medical exemption, unfortunately, are very limited based on what the government has indicated. So if you're an employee who is seeking an accommodation on regarding a vaccine policy, regarding something other than a medical exemption, whether it's religious or otherwise, I definitely think that you're going to have more of an uphill battle in terms of getting additional damages for those human rights or alleged human rights violations. But I do think that by providing this information, and especially giving a letter testifying to certain beliefs within the religious community, can put the employer under a bit more pressure to try and accommodate you to the best of its ability. Because generally speaking, employers have a duty to accommodate you in certain situations. And so if there is a practical solution that can be reached where you're able to continue working for that employer and not get vaccinated, and you've sent them an exemption request, then there could be an argument to be made that that employer has to accommodate you, but it just depends on what accommodation can be provided, if any. So I would say in response to your question there, definitely if there's still some pushback on accommodating you, you may want to get in touch with us so we can take it further from there. Excuse me. And sorry, I'm just going through some more questions. I've got another question coming in from Melissa on Facebook. And Melissa says that she is non-unionized, that she is looking on the government website, and that based on vacation or seniority, she should be afforded some protection. Melissa mentions that she was demoted and that she's not sure why the government site says not to interfere with the terms of her employment, but the employer did. So I hope I'm following along, Melissa, but what I will say is that, and this goes for everyone generally speaking, if you are put in a situation where you're being demoted or the terms of your employment are changing as a result of the employer's insistence and the changes are significant, you have an option as an employee to accept or reject those changes. If you reject those changes and the employer insists that those changes happen, then you have an argument to say that you have effectively been terminated. It's called a constructive dismissal. Now, if you've already been demoted or arguably accepted the changes, what I would say is if there hasn't been too much time that's passed to advise that you're not agreeable to the changes. So I suppose the question is, how long has the demotion taken place for? But you definitely want to object, because otherwise you'll be seen as condoning or accepting those changes, and it's going to be very difficult for you to then go back after the fact and have things rectified. So definitely, if you're in this situation, it may help to get in touch with a lawyer or a law firm, because I don't know if I answered your question in full. I'm trying to understand it as best I can. So maybe that's something you can follow up with us on afterwards, Melissa, but thank you for your question. I've got a ton of questions here, so just bear with me, folks, but I've got another question from Marco on YouTube. Marco is asking, can an employer initiate an unpaid leave? Marco heard that under the Employment Standards Act, they cannot, and can I shed some light on this? So you're correct, Marco, in that if an employer is imposing an unpaid leave on you for an undefined period of time or otherwise, effectively what that means is that you'll be receiving no payment for that period of time. And it sort of relates to what I said a moment ago. If an employer is going to stop paying you for whatever reason, that arguably constitutes a significant change to the terms of your employment. And so you definitely want to object to that unpaid leave sooner rather than later and take the initiative in that respect, because you don't want to be, again, seen as condoning or accepting that unpaid leave, especially if there's no end date to the leave itself. And even if that unpaid leave is in the context of not getting vaccinated or not submitting to testing, it does not mean that an employer has an inherent right to place you on an unpaid leave, and you could be owed significant damages in the form of severance and other entitlements. So definitely get in touch with us, Marco. I'm sure that there's something we can do to help you out and at least guide you in terms of how to communicate with your employer regarding this unpaid leave, because I know this is a situation that a lot of people find themselves in. Going along with the questions, Razor Sharp on YouTube asks, how long can my employer put me on leave? Am I allowed to find temporary employment while I'm on an unpaid leave? So again, an employer doesn't necessarily have any set time that it can put you on a leave. It will ultimately depend on what leave it is you're being placed on. But I know that in the context, again, of vaccine policies, a lot of people are being placed on unpaid leaves of absences for an undefined period of time until you either are vaccinated or until the situation otherwise changes in some respect. And again, you need to take initiative ASAP and not be seen as having accepted that leave. So especially if you're an employee who's got a long service with the company and you've been put on a leave of absence, it's definitely something you want to reach out to us and find out what your entitlements are, because again, they could be very significant. Going through some more questions. Naomi on YouTube is saying that her employers are stating that there's no grounds to support her religious exemption. So again, this goes back to, what are the odds that an employer will accept your exemption, and what kind of exemption is it? And also, what evidence do you have in support of your exemption? So I think that if you're an employee, for example, who is claiming a religious exemption, and all you're telling your employer is that you adhere to a certain religion, but let's say you don't have a note from a religious leader, or you don't have further information to support what it is you're telling your employer, it will generally be harder for you to convince that employer that you should be exempted. And even if you do have that evidence, there's still a good chance that your employer is not going to accept your religious exemption. Unfortunately, there's not a whole lot that we as lawyers or anyone can do to prevent your employer from doing what it's doing. So I appreciate that this may be frustrating for a lot of you, where, practically speaking, you cannot prevent the employer from terminating your employment, or from putting you on an unpaid leave of absence, or from rejecting your accommodation, say for religious reasons or otherwise. But if you do end up suffering in that sense, if you do lose your job, if you are placed on a suspension, if you are placed on a leave of absence, there's a very good chance that you have recourse, that you have rights, that you have entitlements. And so as much as we cannot prevent your employer from practically doing one thing or another, if it happens, we can definitely, or I should say most likely, provide you with a lot of assistance and advocate to the best of our abilities to get you what you're deserving of. So if you can contact us afterwards, we're happy to discuss your case in further detail. So hopefully that answers your question. And again, the prompt is shown up there, contactemploymentlawyer.ca. You can find out more about our firm, where we're located, what areas particular associates or lawyers at our firm practice in, and take it from there. So just going further down, I've got another YouTube comment from Foucault. Forgive me if I'm mispronouncing it. And Foucault is just asking if it's allowed to fart during a meeting, and if that's cause for an employer to fire you. No, that seems quite minor as being a reason, in all honesty, to fire you. And if that's the case and there's no other reason, then there's a good chance that you're at the very least owed severance. That said, employers don't have to give specific reasons as to why they terminate your employment in a lot of cases. They don't necessarily need the best of reasons, but to me, that seems a bit excessive. So that may be something you want to follow up with us on afterwards, and we can definitely help you out to the best of our abilities. I got another question from Essential on YouTube. Essential is saying, I got terminated today. I have my termination papers. It says that I did not get vaccinated by November 1st. I've been calling. So Essential, first of all, thank you for calling in. I just want everyone to appreciate that we are getting a large volume of calls, so we're doing our best to respond to those calls. However, if you've been terminated and you were given papers for not getting vaccinated, much like I said before, there's a good chance that you are entitled to severance, first of all. I don't know if your employer is offering you any particular severance or not, but even if they are, there's a good chance that you're owed more than what they're offering. So you'll definitely want to get in touch with us before signing any documents or signing any kind of a full and final release, and we can look to take it from there. I've got another question coming in from Lauren on Facebook. Lauren says that she is on a leave of absence and she's expected to return to work next week. But then she was notified today by her employer that she needs to be fully vaccinated by November 29th, and that you need to get and that she needs to get vaccinated to comply with the company's policy. She says she works in home care and they're mandating it company-wide. Can I get severance? So again, there's a good chance you can get severance. Now, there are certain industries, as I mentioned from the outset, that there's more of a focus on from a legislative perspective. So, for example, if you are employed in a long-term care home, or you're employed in a retirement home, or you're employed in a hospital, these are just a few examples where there's certain legislation in place dealing with COVID vaccine policies and dealing with whether or not vaccine or alternate testing is required. And so it'll come down to, again, what particular industry you're in and what options your employer is affording you. But there are very, very, very few situations where the government is actually mandating a vaccination, and that only being the only option, I should say. So for that reason, Lauren, I would suggest definitely getting in contact with us because there's a good chance that you are entitled to severance and potentially other things as well. Now, I've got another question coming in from Carrie. Carrie on Facebook. Carrie's asking that, or stating that her employer put her on a 1-month unpaid leave of absence and said that it's their policy not to pay severance. Is that possible? And no. First of all, if someone's employment is terminated or they're placed on a leave of absence without their consent and it's otherwise not justified, there's no policy that says you're not owed any severance. So I appreciate that a lot of employers are telling people that they're not entitled to severance or that they're not going to pay out severance or that that's not in the policy, but do not take your employer's word for that. There's a very, very good chance that they're incorrect in that regard and that you actually have options. So definitely get in touch with us if your employer particularly if your employer is refusing to pay you any severance at all, and nonetheless they stop paying you for whatever reason. So get in touch with us, and I'm sure that we can be of further help to you there. Ilona is stating on Facebook that her employer is saying there's no other choice but to put her on an unpaid leave of absence, even though she's told them she doesn't consent. What are my next steps? Ilona, give us a shout. There's obviously a very good likelihood that your employer is just not going to listen to you objecting to that unpaid leave of absence. It's good that you have objected. It would be good if you put your objection in writing. And this is a general point for everyone. If you object to being placed on an unpaid leave of absence, or you object to any certain thing, putting it in writing and confirming your objection in that regard will be helpful. And as much as the employer may not want to pay you or may not want to give you any other alternative or make any other form of accommodation, that's fine. But that doesn't mean that they don't owe you compensation. And so I think your next steps should be to get in touch with us so that we can get a better understanding of your particular situation, whether or not there is any legislation in place that deals with, let's say, COVID vaccines, or anything of the sort, but definitely get in touch with us and we can take it from there. Leanne on YouTube is stating that she really hopes there are lawsuits coming against the government, regarding the mandatory vaccine policies and everything that has been the hot topic nowadays. The fact that you might get impacted from an EI perspective, etc., and how the vaccinated are. The unvaccinated are getting, I guess, treated in a differential way. And all I can say to that, Leanne, is I definitely appreciate your frustration. But as far as lawsuits against the government are concerned, ultimately that may be what's required. Because as it stands, if the law is saying a certain thing regarding vaccines or regarding testing or any of this, then employers are going to likely adhere to that law. And so they don't want to necessarily have a situation where they keep certain people employed in violation of a particular law, because then that exposes them to additional headaches. And so you're right to point out that the the issue has to do more so in these cases with the law and the legislation, and that's a concern that goes above and beyond your particular workplace environment. But the fact of the matter is that if there is that law in place, and unless the government does change its tune, then all you can do is be advised as to what you could get if you lose your job and what your options are. But practically, it'll be very difficult at the moment to stop your employers from doing certain things, even if what they're doing isn't exactly legal. Getting some more questions here. And Matthew on Facebook is stating that he's not unionized, but he got locked out, I guess, from his company for not signing a payroll deduction form for testing daily. He's saying that they want us to pay $24 a day and want us to sign the deduction form. So there's a bunch of them, according to Matthew, who are on an unpaid leave of absence for not agreeing to this deduction. And that's a good point that you raise, Matthew. That's something I haven't touched on yet. But if your employer is insisting that you pay for testing because it's offering that as an alternative, do not feel as though that you're required necessarily to pay for that testing, and certainly don't sign any payroll deduction form without talking to a lawyer. Generally speaking, companies are not allowed to make deductions in most cases from your payroll for things like that, which is presumably why they're asking you to sign that form. And if the testing amount or the cost of the testing is significant in relation to how much you earn with that company, and they're forcing you to pay those costs, that in and of itself could constitute a termination for which you're entitled to severance. So if you're being placed on an unpaid leave of absence, or if you're being forced to pay for testing and it constitutes a significant amount of money in the long scheme, then that's another situation where you have rights and recourse. And so, Matthew, I would say that for you and those who are in that situation, get in touch with us, because if you've been with that company for a while and this is what's going on, and you're on an unpaid leave of absence, there's still that good chance that you're entitled to some compensation. I've got some other questions coming in from Vicky on Facebook. Vicky's asking, would severance negotiations take into consideration the fact that even though I'm young, being able to find suitable employment with a six-figure salary would be difficult given the mandates in my industry, et cetera, et cetera? So, and Vicky's asking, does this hold weight? And if so, how much? So you're correct to point out that for the most part, how old you are, how much money you make, what position you have, and how long you've been with a company are all relevant factors in determining how much severance you could get in your particular situation. And as you rightly pointed out, it all has to do with your ability to find suitable, comparable employment. So the longer that it would take someone in your shoes to find that employment, there's a good chance the more severance you could be owed, and things like your age and how long you've been there and how much you made and all that, as I say, factor into what is available out there and how long it could take. So that's all, that all does hold weight in all likelihood, because those are the main factors that the courts look at when trying to assess generally how much severance someone should be entitled to, in addition to whether or not you signed a particular contract of employment and what that says. So I've got a number of other questions coming in. I'll answer one more, but after that, I'll have to leave you for the day. So Lorraine is asking, can a unionized employee opt out of the union and seek independent counsel? Again, it's very difficult. The cases where people challenge their unions with respect to how they're advocating for them oftentimes fails. I don't want to give you the impression that you're completely dead to rights, but I will say that we don't practice unionized matters at our firm, and at the very least, maybe that's something that you can get in touch with on with a labor lawyer who specializes in unionized matters. And actually, I'll answer another question. Anna on Facebook has said, he said you should not sign any document regarding payroll deducting money for testing. Oh, sorry, Anna, you were just perhaps referring to what I said earlier. Yeah, this pertains to anything. If your employer is asking you to sign a document and trying to get your consent to do something, whether it's to put you on a leave or to take money out of your paycheck or anything that would affect the terms of your employment, be cautious before signing those things. You don't want to be held to that, and sometimes it can be very difficult to get over that hurdle if you've already signed that document. So get in touch with us if your employer is forcing that. I will, however, leave you on that note. We do have another session coming up this Wednesday, as noted below, Wednesday, November the 3rd, with Lior Samfiru. So Lior will be here to answer any other questions that you have. I do very much thank you for all your time. I apologize for not getting to everyone's questions, but I will definitely be back myself in the near future, and I'm looking forward to that happening. In the meantime, contact us at employmentlawyer.ca. That will give you a better idea of some of the services that we provide, where our offices are located, and how we can be of help across the country. And we also have pocketemploymentlawyer.ca as well that can answer some of your questions, both relating to the COVID-19 pandemic, but also relating to other things. For example, what factors go into severance, what can trigger your severance entitlements, what can't, and that kind of thing. So definitely check us out on the website. But thanks again, everyone, for your time, and I will be in touch. But otherwise, take care until next time.